There's an important Supreme Court case touching on Second Amendment issues, although it's not obviously the Second Amendment. Specifically, it talks about the First Amendment's right to free speech. We're going to talk about this and why it matters to your rights when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're working really hard to try to get to 100,000 subscribers, which will make a big deal in terms of the algorithm dealing with social media. All right, folks, so sometimes we talk about other legal issues and cases that touch on the Second Amendment, but maybe not so obviously or directly. That's one of the things I want to talk about today, the case called 303 Creative versus Elenis. You may have heard about this before. This is a case involving a female Christian graphic designer that under Colorado law, allegedly is required to make websites that express opinions and viewpoints that she disagrees with based on her Christian faith. Specifically, she does not want to be required to make websites for gay weddings, same-sex marriages, and the like. She says this would violate her fundamental belief system as a Christian. She brought a lawsuit against Colorado's anti-discrimination law that says that you can't discriminate on the basis of same-sexness or gender or anything along those lines, sexual orientation. And based upon that, she said that this would require her, once she opens her graphics design company up, her web design company up, that would require her to potentially service individuals that want to have gay weddings or same-sex marriages or anything like that. And she does not want to have to be forced to create imagery or websites or otherwise express support for this because, again, she says it would violate her Christian beliefs. Now, she sued preemptively, claiming this violated her First Amendment. Now, remember, the First Amendment includes several rights. One of the rights is the right to free speech. But the right to free speech is not just the right to speak freely. The right to free speech under the First Amendment, part of the Bill of Rights, which also includes the Second Amendment's right to keep and bear arms, part of the right of free speech under the First Amendment is not just the right to speak freely, but it's also the right not to say things you don't agree with. In other words, the government cannot compel you to articulate messages that you disagree with. So that is why she is claiming that if she opens up her business, and when she opens up her business, she doesn't want to bring, make representations or statements or do visual art or graphic art or websites for things that she disagrees with because they violate her Christian faith. Now, the reason why this is important to the Second Amendment is keep in mind that we see a nascent growing movement among the anti-gun community to try to force, for example, gun shops, gun dealers, maybe even gun shows to display anti-gun propaganda, in my opinion, specific things to say guns are extra dangerous because people may, commit suicide at greater frequencies. Probably all that's untrue. The guns, kill people, et cetera, et cetera. So basically, the idea that anti-gunners can pass laws that require gun shops and people in the business of selling guns or marketing guns or gun-related products, that they would be required to provide this information to consumers under the name of making sure that everyone is fully informed. So that's why this case of 303 Creative is so important, because we want the U.S. Supreme Court to come out and make clear that under the free speech rights of the First Amendment, individuals should not be forced to embrace viewpoints or thoughts or beliefs that they vehemently disagree with. And it doesn't matter what you think about the gay marriage debate one way or the other. The point is really a First Amendment free speech point. And again, it's the kind of precedent that if you get a strong precedent here that says that not only can you say what you want, obviously, you can't commit fraud or defame people, but you're basically allowed to speak freely, but you're also not allowed to be compelled by government to articulate views that you disagree with. This has the potential to be very helpful if the precedent is written right by the U.S. Supreme Court in the 303 Creative case to help those gun shops, gun dealers in places like parts of Maryland and other places that may be forced to articulate and hand out literature brochures that are really anti-gun in nature at a gun shop. So we want to nip this kind of anti-gun stuff in the bud, and I think a strong decision by 303 Creative by the Supreme Court would be very helpful in this regard to remind people that, again, the First Amendment prevents the government from making you make statements that you disagree with. This may also be extremely helpful in the New York cases involving firearms being carried onto private property. Because again, as you know, in New York, they're trying to say that you're not allowed to bring a gun onto in a private business unless that private business expresses support for gun rights by saying that we welcome guns or guns are allowed here, which to me is kind of the same concept where the government is forcing businesses to openly and expressly opine or make statements that they support gun rights, that they support guns on their property. They're compelling private property owners, business owners to make a statement in favor of gun rights, which is nothing wrong with that as a conceptual matter. But as a legal matter, the government is not allowed to compel people to make these kinds of First Amendment statements or these statements that they disagree with or statements they don't want to be forced to say. So even if they support gun rights, they may not want to publicly express that out of concern that their neighbors or people may walk away or get angry or egg their cars or vandalize their businesses. We've seen this over and over again. So again, yet another reason why we in the Second Amendment community want a strong decision by the Supreme Court saying that government actors, whether it be the state of Colorado or the state of New York, cannot force individuals to embrace viewpoints or articulate messages that they disagree with. So in 303 Creative, I think the Second Amendment community should be cheering for the plaintiff, Lori Smith, here to become victorious, because that will be a precedent that strengthens the First Amendment right not just to speak freely, but also not to be compelled to say things you disagree with or vehemently oppose, or messages that you don't support, which I think is helpful to the Second Amendment community, given where I think the anti-gunners want to take us if they have their wills satisfied. Okay, hope you learned something here at the Four Boxes Diner. Take a look at 303 Creative, and if you haven't subscribed, please do so here at the Four Boxes Diner. We'll see you again soon at the Four Boxes Diner.
Orders up. Table 2A.